Sunday night sucked. We missed 2 Sundays in a row, and I don't like missing Sundays either because it has become my ritual as well. And here's the big problem. Next Sunday is my birthday. And I don't know what we're going to do, but I think we might do the stream on Sunday of my birthday because first of all, not only do I not mind, there's part of me that feels that is the 42nd birthday. Sorry, let me get this off here. My 42nd birthday next Sunday. That F, booyah. That means we are perfect, live, and on time, by the way. Whose chow is that? Tor's Fire. I do apologize, and I'm not saying that sarcastically. The Sunday night has become my ritual as well, and I missed it 2 Sundays in a row, and I think it confuses people. It affects the live stream mojo that we have spent the better part of a year getting into effect. Mandy Amos in the house. This joke goes back a long ways. You can buy a dog from Fenway in October. I don't know if that's directed at me, but okay. So everybody, Viva, can you have Lord Monkton as a guest? He said informed by... okay, I don't know. I'll look into who that is. Let me just take a screenshot. Get back to that afterwards. Okay. So I will admit that I have been a little down in the dumps over this weekend and in general. We're going to start with the Viva rant because the world does not seem to be getting any saner, any more logical, any more interested in reasoned discourse and discussion on, minor issues like our most fundamental civil rights and liberties. And it almost seems to be accelerating in the wrong direction at an accelerating rate. The anecdote of my weekend, which kicked it all off, was Friday night. I'm in the park, still in curfew, by the way. Still in curfew in Quebec. Tomorrow, our Supreme Leader François Legault is going to announce some wind down measures. I don't know what's going to be announced, but everyone who's been following my channel, my Viva on the Streets, for a while now, started in January when we had our 4-week curfew to stem what was increased hospitalizations in ICU in January 2021 in the context of a pandemic that had been going on for almost a year. A 4-week curfew. At that time, I thought the curfew was unjustifiable, but I'm not a policymaker. The curfew was imposed in January when we had a little over 200 people in ICU and about 1,000 hospitalizations in a province of 8.5 million. And we were told this was a 4-week curfew to not overwhelm the hospital facilities over January. 1 year into this pandemic, when they had been predicting a second and third and whatever wave for a year. I thought it was unreasonable, unjustifiable, and absolutely unconstitutional then. And I said, I'm just going to do daily Viva on the Street updates until this is over. We're 4 months in, we're 5 months into it now. Right now, our numbers are half what they were at the time this 4-week curfew was imposed. And instead of people clamoring and people chanting and people marching for their rights, this curfew has just become another tool in the arsenal of the Legault government to coerce something out of us in the future. We are entering 5 months of a 4-week curfew. The numbers now are half what they were when this curfew was imposed, and nobody cares. It's almost as though it feels like people need to be told what time to go to bed. And all that to flip it into the fact that I'm in the park on a beautiful Friday evening. It's just my family and another family who I didn't recognize, but 2 kids, young kids, I don't know, 4, 6, 3, 5, wearing face masks with the mother. And we're all distanced and there's no one else there. And I said, if you're wearing the masks for us, you can take them off. You don't need to worry. And then she said, no, they always wear them. And I swear to you, it hurt my stomach. And that just put me into a downward psychological spiral for the better part of the weekend. I'm celebrating my wife's 40th birthday. You all knew that Saturday night. We have to celebrate it with videos that her friends are sending her and gifts that are opened, in the solitude of our home, which is not really, our family, but we've replaced celebration with video, Zoom. Like that's a substitute, like that's reasonable at this stage of the COVID. Like, that's reasonable at this stage that the border between Quebec and Ontario is still closed. Okay, that's not the rant. You know what? Let's do the rant before we even get to the super chat standard disclaimers. The border between Ontario and Quebec is still closed. I have brothers in Ontario that I haven't been able to see, nephews, because interprovincial travel, that small constitutional right that exists in our Canadian Charter of Human Rights, and just that small thing. No. And the border is still shut. Why? Because they have hundreds of people in the ICU and thousands of hospitalizations, like maybe in the 1500s, I think, last time I checked, in Ontario. Population 14.5 million. So they shut down the border, tried to do house arrest, but even the police in Ontario said they wouldn't do this. Meanwhile, out of Nova Scotia, you get courts issuing injunctions to prevent the threat, the stated protests, unmasked protests, or protest against the lockdowns and the face masks. Court issuing injunctions to enjoin, prevent, prohibit public protest. Alberta did the same thing. This is it. Minor details. Prohibit the right to protest, the measures that have been crippling our society for the last year. And if you take issue with it, I just heard a massive thump upstairs. If you take issue with it, the government portrays you as the extremist, the right-wing nutcase who's just selfish and just wants Granny to pass away. You got Jagmeet Singh, the leader of the NDP, saying that if you're anti-face mask, I don't know exactly what scope, if you're anti-face mask outside, that it's a selfish decision. And he's noticed this selfish modus operandi, with far-right extremism. This is the level of political honesty and discourse, to demonize anybody who dare disagree and anybody who dare say, yeah, even when you're mitigating an emergency, if that's what this is, even if you're mitigating an emergency, you kind of have to do it in as much as possible in tandem with constitutional rights. But our rights don't exist. They just don't exist. And the courts are sanctioning the government-imposed edicts, and it's atrocious. Okay, just look at how large Viva and Barnes has become. Congrats. Thank you very much. I see your what? Aha, ACOR. Speaking of ACOR, our AC is again not working, but we have to redo the roof or re-tar the roof, so the AC is not working. It's hot and cranky and yada, yada, yada. Okay, I got a new fishing rod, so stick around for some fishing videos. Alex Ambrose says, you should read Cults in Our Midst by Margaret Singer, first book reference. It's scary how much government behaves like cult leadership. Jagmeet Singh actually said that if you're anti-mask, it's a right-wing extremist thing. As if to say, anybody who thinks maybe you don't slap masks reflexively on children, you're a right-wing extremist. Don't listen to them. They like to play Yahtzee on the weekend, if you know what I'm saying. I missed all of the super chats, and now I'm going to get to the first disclaimer because I see Robert is in the house. I think he's smirking at my... I got so angry over the weekend, I just couldn't talk to people. I just couldn't. I was outside, and I could not smile over the weekend. It was depressing. Then I went to the Orange Julep last night, and that changed a little bit. The UK government admitted to using hyped up fear and mind control techniques in order to get people to accept lockdowns. Oh, yeah. And if you discuss these things, you're a conspiracy theorist. You know, the conspiracy theories that were forbidden, the Voldemorts of YouTube in 2020, lo and behold, there's actually some truth in them, but we're not even going to get into that. Okay, standard disclaimers. Let's get into this. It gets hot in Canada, only in the basement, only in our house. Our house is hot in the summer and cold in the winter. Okay, standard disclaimers. First of all, we're streaming live on Rumble, so everyone can watch us there. I don't know that they have chats yet on Rumble. Oh, Jay Mill, I like that idea. That is what I think I want for a birthday gift, a good fly fishing rod, and I'm going to get into that. I once hooked myself in the back of the leg fly fishing. Swung it around, wind blew around my leg. I whipped it into the back of my leg. The hook went fully in. I had to go home. My dad had to pull it out with a wrench, suck the blood out to remove the dirty blood. Your wife is a little over 25. Save your life. Okay, so standard disclaimers. We're live on Rumble. I may not get to all the super chats. If I don't get to it, don't read it out loud and it's going to miff you. Don't give the super chat. I don't want people feeling rooked, grifted. YouTube takes 30% of the Super Chat. If that's a problem with you, and I can understand it is, you can support us on Locals if you want to. If for whatever the reason you don't want to support us on Locals, there's Patreon, Subscribe Star. You can buy some merch. Links are all there. No legal advice. And what else? Keep the chat civil, please. Although, internet is what it is. Let's do this. Let's bring on the Barnes. Oh, and on the menu tonight, I'll bring in Robert. Robert, how you doing?
Good.
We don't have it on our menu, but we got to get to some of the Canadian decisions, Robert, because I think they'll blow your mind. Two things. We'll get to the Canadians ones. We're going to get to Fourth Amendment affirmed by the Supreme Court. What were the other ones? Florida suing the Biden administration. The Florida suing the CDC and the government, or just the government. Bars suing Biden for discrimination, racial discrimination, tax issues. The lawsuits just keep coming. And I did as much of the homework as I could that you gave me, but I was preoccupied with family stuff and frustrated all weekend. Robert, coming out of Canada. Let's start with the first one. Pure Canadian content. The CBC, the Canada Broadcasting Corporation, a crown entity, which means it is a government corporation. They are subsidized by the federal government to the tune of $1 billion a year. And they get a bunch of other perks. They get a bunch of other benefits. And they're funded by the federal government, which happens to be a liberal government. In the election cycle of 2018, the CBC, who's so strapped for cash that they need government subsidies and government handouts, they found it in their pocketbooks to sue the conservative government for copyright infringement because the conservative government used some of their news footage and tweets in what they turned into a political ad during the 2018 federal election. CBC sued, took an injunction. They lost then. I'm fairly certain they lost then. They lost now ultimately. The court basically, it was a no-brainer. Determined it was fair. We don't go by fair use in Canada. We go fair dealings. But they determined it was fair use of otherwise copyrighted material. The tweets are not copyrightable from what I can understand. Robert, the question people were asking, and in Canada, I think the answer is no. In the States, for example, the NPR, which receives federal or receives government funding, do they own copyright over their material?
I think so, but to be honest with you, I don't know. I assume so.
And I think the answer is yes here, where just because it's government funded doesn't make their material public domain. But the CBC sues the Conservative Party, sues the Conservative Party using federal taxpayer dollars coming from the Liberal government of Canadian taxpayers to sue the political opposition. What do you think when you see these types of things coming out of Canada? Does it shock you, or do you say this is just par for the course in politics?
Well, I mean, the Canada's just a little bit more to the kind of statist left, if you will, more of a neoliberal political domination. The Canadian type ancestral audiences in the States, the old Yankee populations are similarly minded. So it doesn't really surprise me too much. But good court decision that it recognized the right of fair use.
And I mean, the court decision was as, it was as fair and favorable to the losing party as it could be. They said, there could be situations, because one of the arguments they raised, incidentally, was not just copyright infringement, but that the use of the material could compromise not the moral, but the moral standing, the reputation of the CBC, as if they were splicing grossly offensive content with the CBC where it might damage their reputation and their goodwill. The court said it's fair dealing. There may be circumstances in which this could compromise the brand and integrity of the CBC, but this is not one of those cases. I mean, to give them all of the benefit of the doubt they could, but basically saying this was a terrible lawsuit. And I mean, they didn't say it was politically motivated, but it's just, it reeks of political motivation on its face. The Liberal Party made the same use of some material, didn't get sued. And it just looks like it's state-funded broadcasting, doing the dirty work for the political government. And this time the courts didn't side with them. But you heard about the Nova Scotia decision where the courts outlawed a protest. I mean, yes. Robert, chances of that succeeding in the United States?
Man, before all of this, I would have said low, but it's a different world right now.
It's amazing because basically Nova Scotia said the risk of a public protest is such that it's an immediate concern. They met the threshold for the issuance of an injunction, and they said the risk of the negative consequences of allowing it are great enough to warrant the injunction. I don't know how they get over it, because appealing an injunction in Canada is difficult as well. So there's almost like a great amount of deference to the trial judge who issued the injunction. Same rules in the United States?
Not necessarily. If it's a question of law, there's no deference.
Okay, and I think that might actually be the case in the States. Anyhow, so that's the beauty coming out of Canada. On the one hand, the court's not doing the dirty work for the government, sticking to, the obvious decision, but it's a moot point in any event because the federal elections are 2 years old. In the other case, prohibiting the right to peaceably assembly, notwithstanding the fact that Justin Trudeau just tweeted today, you have the right to peaceful assembly, just don't protest for the other reasons that are going on in the news. Okay, Robert, that's what's going on in Canada. If we bring it into the States, what do you want to start with tonight? Do we start with Florida suing over the CDC guidelines?
Sure.
Okay, so I've read the lawsuit briefly. Basically, the CDC, Florida is suing who? They don't sue the CDC directly, correct? They sue the government?
Yeah, I mean, they're suing the cabinet official that runs the Department of Health and Human Services that supervises the CDC, though it does. The CDC is also a named defendant. When I was first searching the suit, I couldn't find it because I didn't realize it's like Centers for Disease Control rather than, I don't know. It's some like there's an extra S somewhere along the way that totally changes your ability to search for it. But but that's the nature of the suit. It's the actual state of Florida is a plaintiff, and the Center for Disease Control is a defendant. But the primary defendant is the cabinet official that runs the Department of Health and Human Services, the former Attorney General for the state of California. All right.
And now the essence of the lawsuit basically is that Florida, things are opening up everywhere with the exception of the, I just lost the word, those big ships that have people, cruise ships. And so the CDC has set out guidelines for the reopening of the cruise ship industry. And I screenshotted it because it was just so outrageous in terms of what they were asking for to reopen. I want to read you the criteria that they were asking for to be reopened. After discussing these alternatives, this is the order coming from the CDC, explains its plan for reopening. The plan involves 4 phases. 1, establishment of laboratory testing of crew on board cruise ships in U.S. waters. 2, simulated voyages to test a cruise ship operator's ability to mitigate COVID-19 on cruise ships. 3, a certification process. And 4, a return to passenger voyages in a manner that mitigates the risk of COVID-19. So this is what the CDC is trying to impose by way of guidelines, which basically says if you can't satisfy those 4 conditions, you're not opening at the very least until November 2021. What Florida's arguing is that, first of all, cruise ship industries overseas is open or opening gradually, and apparently hundreds of thousands of people are getting on cruise ships. That the measures the CDC are implementing, other than being arbitrary and capricious, are counterintuitive, because what you're going to do is compel people to fly over to Europe to do cruise ships, come back, and so you're not actually mitigating anything. And apparently they said the safety measures on cruise ships was even better than on land. That's an evidentiary issue. But I mean, Robert, this is again testing the authority of the CDC to govern private enterprise. I mean, where's the limit to their authority? We saw it with the moratorium, but where's the limit to their authority?
It's pretty much like the eviction case, because the CDC is claiming the same basis of authority. So the statute and the regulations only talk about the CDC being able to quarantine individuals that are contaminated in some manner or carrying an infection in some manner, the ability to fumigate, the ability to seize boats for a temporary time period for the purpose of fumigation. And they're saying based on that, they have authority over the entire industry. And so the first core objection that the state of Florida makes, and the reason why the state of Florida has standing, is because this is prohibiting cruise ships from docking and taking on customers in the state of Florida, whereas it's their primary location for cruises is out of the state of Florida. And that's why they're suing. So they're suing on behalf of the cruise industry because of the economic detriment it is imposing on Florida. But their first objection is CDC simply doesn't have this authority. The statute doesn't give it to them. The regulations don't give it to them. The second part is, the old statement constitutionally has been if Congress does not give an elephant-sized authority out of a mouse hole. And so the point is, if they want broad authority, they will give it. And if they don't, you can't have it. The second is, to the degree that the court claims that they do have such authority, then it's unconstitutional because it's a delegation of legislative power to the executive branch. The executive branch can't write laws, can't make laws. They can only enforce laws. And here there's been a derivation of that doctrine by allowing them to pass rules and regulations under certain procedures and protocols. But there's always been limits to the constitutional scope of it, and I hope the courts pull that back altogether. The third is that they didn't go through the regular APA process. They didn't do meaningful notice and comment. They didn't do meaningful evidentiary evaluation. And here it's similar to the Stickman case, similar to the eviction case, in that the evidence is that CDC doesn't have evidence for why they did what they did. They don't have evidence for what alternatives they looked at. They didn't have evidence for whether they looked at what Florida, the state, was doing to accommodate for this. And that's part of the arguments that they're making, is that they didn't even go through they don't have constitutional authority to do what they're doing. They didn't even go through the evidentiary process that we test to make sure that we can have confidence in whatever evidentiary outcome that they came to. And third, the evidence doesn't support them and substantiate them. And last but not least, noting the obvious contradictions. They're not shutting down the airline industry, but they're shutting down cruise ships.
No, it's amazing.
Great.
They don't shut down the airline industry, and they didn't shut down the hotel industry. I mean, they just have certain restrictions. Whereas a cruise ship is effectively as condensed. It's probably not as condensed as an airplane, but it's sort of packed, and it's basically a hotel. And I don't know what the evidence is in terms of how safe it is. But to say that the cruise ship industry cannot operate at means similar to hotels and the aviation industry doesn't make sense. I had no idea it affects so many people. The suit said something like 170,000 people depend on the cruise ship industry for employment in Florida.
Yep.
The evidence, well, and apparently one of the arguments they also raised was that the protocol or whatever measures they implemented were before vaccination, and that the situation has changed.
Right.
Why? I mean, what's the rationale? Do we have any? Do we know why the CDC would treat the cruise ship industry different than hotels and aviation?
They don't really have compelling arguments. They had an evidentiary hearing last week on it, and the court said, or kind of more like oral arguments than an evidentiary hearing on the TRO. And the court was sympathetic to the CDC's position on the whole scary virus routine, but was skeptical of the CDC's provision of not having any hard deadline. So it's one thing to have shut this down a year ago. It's another thing to shut it down continuously now. And it's definitely another thing to not have a hard deadline as to whether you're ever going to allow it to reopen. So I think on the policy grounds, you saw judicial deference, as we've sadly seen throughout the decision to the public health industry. But we did see some legal skepticism. And the biggest problem the court has is the Sixth Circuit's decision affirming the CDC's lack of authority to regulate evictions. A lot of the language in that decision clearly applies here. CDC hasn't really explained how they suddenly have this massive authority, hasn't really explained why they skipped the notice and comment process, hasn't really justified how this is constitutional, didn't really produce any new evidentiary arguments that they either followed the procedure correctly or that they had independent evidence that others were unaware of as to why this targeting was justified and warranted. So in my view, the decision should come down in favor of the state of Florida. But it may be maybe one of the Solomonic split the baby decisions where he says they could have such authority but didn't properly substantiate it, or that the deadline can't be ceaseless. Just filing the suit has delivered some results because the CDC started to modify a range of policies in this context in response to losing the eviction moratorium suit and now facing this suit. Because the reality is, dig deep, they don't have strong evidentiary support for what they did.
I mean, the easy explanation or the easy example they can come up with was the outbreak on that ship where everyone was docked. Where was it? It led to a lawsuit.
I think it was docked in Japan, the Diamond Princess.
Yes, Diamond Princess. So they're going to have examples of outbreaks on boats. Whereas I don't know. I don't think.
But they have other remedies. If there's an outbreak, they can quarantine the boat like they did the Diamond Princess. I mean that's the problem here. There's so many alternative remedies available, even if you fear an outbreak, that you can particularly because it's a cruise ship, you can more easily contain it. That's what the quarantine process is there for, not to shut down the whole industry.
And that was historically what quarantines were. You dock the boat for 40 days, quarantaine, and you let the people on the boat prove that they're not ill. Yeah, but there haven't actually been any notorious cases of outbreaks on hotels or as a result of air travel, right? Not that I know.
In fact, air travel, because of the filtration system. I mean, that's one of the other problems. They could put internal filtration improvements on cruise ships, and to my knowledge, they've actually gone about doing that, because the nature of COVID is that the reason why it hasn't traveled much on airlines is their filtration system is so good, it simply doesn't circulate. It's weak filtration systems indoors that have been the main circulators. And as a recent articles detailed, I think even the New York Times, it was the New York Times, the Washington Post acknowledged, it turned out all the assumptions about bar and restaurant spreading the virus turned out to be wrong. So that they thought there was going to be this massive expansion once bars and restaurants opened in various states. Didn't happen. So their assumptions behind this are just not well substantiated. And there just has never been a good risk-benefit analysis publicly produced. And so if such a risk-benefit analysis has been done, it must not support positions like the CDC's or the lockdowns because they failed to produce them and publish them. So either they've completely failed to do them, which is what Stickman found in Pennsylvania's case, or they've done them and they're hiding them because the results look bad. But, my view is we trust the process in America to come to good decisions. If you don't even employ the process, you can't trust the decision.
Hippoopy says, got the coof on a cruise ship in March 2020, nearly killed me. I will still cruise. I always viewed cruise ships, as I pulled up a comment earlier, as floating Petri dishes. They are kind of gross, but not really. The thing that got me the most on the cruise ship was the buffet with the food issues, like people touching the food and, getting the food. Those are easy to deal with.
That must drive you crazy.
Oh, no. And everyone knows I was neurotic before this started, which I think prepped me for dealing with this reasonably compared to those who were not neurotic and got easily traumatized. But my way of dealing with any potential bacteria on the food was just to wash it down with a nice snifter of scotch, and that'll kill the germs. I have a theory. But but nonetheless, there are ways that you can deal with this without shutting down an entire industry. Our Prime Minister Trudeau, no notice and comment period, just banned it basically for the year. Who cares? But we only had cruises really on the West Coast and East Coast. It's not. I don't think it's as big of an industry as it is in the States. Certainly not for some provinces as it is big for Florida. But no discussion, just done. We'll see it in a year, and people are going to fly south now, exactly like this lawsuit said, to go do cruises in Florida, fly up to Burlington, and then drive through the border and bypass all of these rules. And it just basically penalizes the least advantaged economically, and those who have the means are going to be able to get around it. I'm just nervous, Robert, reading it and seeing the decision that a judge is going to have to come to in this, which is a decision that's going to affect potentially hundreds of thousands of people, may not want to stick his or her neck out there and say, I'm gonna strike it down and let the industry go. And if there's an outbreak on a boat, they're going to blame me for killing Granny. That's what I think and fear might happen. What do you know of the district in which the suit is filed and the reputation of that district?
It's the Middle District of Florida, wide range of judges. I haven't looked up this particular judge's background, so I don't know how that might play out. I just saw some of what the judge's comments were, and it sounded like there was deference to the CDC, but concern about the lack of a hard deadline. So that's where there may be a compromise outcome, but it wouldn't surprise me to see that case go up to the 11th Circuit, even potentially get up to the Supreme Court. And I would like to see good case law extended along the lines of the eviction moratorium, recognizing that this is not an excuse and pretext for massive power grabs by federal executive branch officials in the name of a scary, scary virus.
And then the rationale would be, if there's an outbreak, CDC comes in and deals with that on an individual basis. If it becomes an epidemic, a big problem, then government officials come in, but it's not the CDC's authority to bypass that entire process and make preemptive, preventative measures that cripple an industry.
Especially when they weren't given the lawful authority and they haven't even gone through the procedures that we could have confidence in their outcome. So at least of all, actually produce evidence that justifies their decision.
All right, now I'm going to read this because on a serious note, this is from Basil the Musical and Pump and Seagull. On a serious note, you guys need to contact Ian Runkle of the Bailey. He has emailed me. I think I emailed back. If I didn't, it's going to happen. So I've contacted him and It's going to be on the to-do list. And we have here, Harris says, I lived in Nova Scotia and chose a real bad time to read Atlas Shrugged. Okay, well, so we'll see what happens in Florida. It's an interesting case. See if it goes the same way the moratorium did. Keep up the good work. Thank you very much, Perry. What do we transition that one into? What was the other one?
I mean, there's a couple of good Supreme Court decisions. One that was a good Supreme Court decision and another Supreme Court decision to take up a case.
Let's do the Fourth Amendment search and seizure. Interesting case, unanimous decision, which tells you a lot about the decision. The fact pattern of the case, I don't know the lower court decisions, except for what I surmised from the Supreme Court. Basic idea is husband gets into a fight with his wife. At some point during the argument, puts a weapon of sorts on the table and asks his wife to terminate him. I'm using these ridiculous euphemisms. The wife leaves the house, goes to a hotel, gets concerned, calls the police. Police show up. He's on the porch, admits basically the tenor of his disagreement with his wife, agrees to go to a psychiatric hospital for evaluation, gets in an ambulance after having been assured by the police that no one's going to seize any of his firearms or whatever he's got in his house. Gets in and goes. Apparently, the police misrelay that discussion to his wife. They say that they need to get into the house without a warrant, without any authorization from court. Under the concept, you'll explain to me what it is the community caretaker concept. And they proceed to go into his house without a warrant, without any authorization, and seize his firearms. And he's sued, and the lower courts seem to have upheld the search and seizure on that basis. Is that fair enough? And for anybody who doesn't know what the community caretaker principle is that a principle of law that people should be aware of or that exists in the states?
It was an attempt by policing officials in states across the country to carve out another exception to the Fourth Amendment. And in this context, this was the case where the Biden administration argued to circumvent the Second Amendment as well, that you could have, on grounds of public health, go around seizing people's guns even inside their own homes, as well as on the grounds of public health, seize them or seize or search anything they wanted under the so-called community caretaker exception. It's another one of those doctrines that was mostly invented by governments that was green-lit by lower courts. Supreme Court never said anything like this at all.
And they did mention that in the decision. They said, we've never said it. I mean, verbatim, we've never interpreted it this way. Sorry to interrupt.
That's exactly right. And so it was, and partially it's on the Supreme Court for letting this fester. They do this a lot. They let lower courts come up with creative inventions. So usually it's governments come up with creative inventions of prior court cases that they know is wrong. They did this famously in the Rooker-Feldman doctrine that was just made up. And they allow this bastardized version to grow and expand and wait a couple of decades before they step in and clear it up, unfortunately. So this case had Second Amendment implications and Fourth Amendment implications and lockdown implications, which you partially see reflected in the concurring decisions issued. So very good news that Justice Thomas's decision was a five-justice decision. Roberts and Breyer wrote their concurrence. Alito and Kavanaugh wrote their concurrence, but it was very rewarding to see that the five justices joined Thomas's opinion, so it's the binding precedent, because it means it likely has consequences that Roberts and Breyer and Alito and Kavanaugh are pretending it doesn't have. Because they reference in their concurring opinions, this could be interpreted as impacting red flag laws, as in red flag laws being unconstitutional. This could be interpreted in a wide range of contexts. This could be interpreted to limit the emergency exception that they use to raid people's houses, which is usually bogus too. But technically they don't fully deal with that, but it does have those potential ramifications. But so the key was there was no the community caretaker reference simply came from a case where they pulled over somebody on the side of the road and said you could search or seize a gun in that situation. That's a totally different circumstance. They protect cops' abilities to do things on the road, I think more so than is justified, but totally different than a broad walking community caretaker exception to probable cause and definitely in the House environment and in the gun environment. So all 9 justices agreed there is no such community caretaker exception to the Fourth Amendment, period. It doesn't apply in the home context ever. It doesn't apply in the gun context, period. So those are major, major rulings. And interesting enough, I'll give Kagan and Sotomayor credit because they have been stronger on Fourth Amendment issues, and they joined Thomas's decision. It was good to see Gorsuch, not a surprise. Thomas and Gorsuch are the best on Second and Fourth Amendment law. But it was very promising that Barrett joined that 5-judge justice majority too. I think she will be good on Second Amendment issues, but this is the first time she's been very good on Fourth Amendment issues. So that's a promising indicator.
And that is the distinction here, that this was not specifically, but only incidentally or tangentially a Second Amendment issue, in that this was search and seizure. So the court could get around, or they could carve out the fact that it was a firearm that was at issue, but treat it only as a search and seizure issue.
Yep.
The idea being that maybe they're going to come down differently when it comes down to Second Amendment issues and red flag laws, or did you get an indication from this that it's going to reflect?
Well, the reason why they wrote concurring decisions, Roberts and Breyer wanted to preserve the emergency exception, so they pointed out it doesn't impact the emergency exception. But again, the 5 justices didn't join that concurrence. And then the Kavanaugh-Alito referenced that it didn't necessarily impact red flag laws. But again, Thomas's decision doesn't say that. So I think, Thomas carved out a very broad Fourth Amendment provision. And what Biden administration was effectively arguing was for kind of a exception to the Second Amendment that would create an exception to the Fourth Amendment. That because it's a gun and it's dangerous, you should be able to use your public health excuse to seize it, even inside somebody's home. That was the argument they made on this case, and that was completely rejected. Nobody accepted it.
I guess you're going to have to flesh out the red flag laws. I mean, I have an idea as to how what they are, but when I read this, at the very least, the decision without having read the underlying proceedings or the previous court case, the court judgments, this it sounded like a red flag law where the search and seizure was an incidental issue to the fact that this was a guy having mental problems, some psychological troubles, voluntarily went to a psychiatric evaluation, and it was a question of seizing the firearms in particular to prevent the potential. Was in the underlying decisions or the underlying proceedings, was it played strictly as a seizure, Fourth Amendment, or were they discussing even incidentally potential red flag laws in this particular case?
Well, where this came up was actually at oral argument before the Supreme Court. It was Biden's Solicitor General that argued because it was a gun issue, you should have a public health exception to search and seize it. That they were arguing that, maybe you generally don't have a caretaking exception to the Fourth Amendment, but in the context of guns and public health, maybe you should. And the fact they did almost all the red flag laws are premised upon an idea of public health community caretaker exceptions to constitutional rights, including the Second and the Fourth. And almost all the lockdown logic that gets into Fourth Amendment issues is based on that. So the fact that they shot that down, it shoots it all down. In other words, you're back to emergency exceptions, the only ones. Now, the hot pursuit case is still pending before them. So we'll see whether that's the other main exception right now. But the only ones that they really talk, and again, 5 said the majority binding precedent was there's no community caretaking exception, period. And there's emergency exceptions, but we don't deal with that. But community caretaking and public health ain't one of them. So that has big ramifications across the board that are very promising moving forward.
Now, I'm going to read this one from Little Rock and then ask you a question about red flag laws. Had a recent case about dog search and 8th Circuit overturned my win. The cops basically used the dog to circumvent the 4th. This was dog use on car in front of storage building with warrant on storage. Okay, it's interesting.
Those are the magic dogs. It's like cops have magic smelling abilities. You may not know it, but they can smell marijuana miles away. They can smell all kinds of things. And this is where the dogs smell things that dogs usually don't smell. And they say, oh, the dog was barking, or the dog didn't smell. They just claim the dog did. And so it's another way they try to get around it. Now, arguably, under the Coco decision, this should not be approved or okayed, because you can't use infrared to search a house. How can you search a house or search a building or search a property through a dog's nose? That's somehow supposed to carve out an exception. And more often than not, if you really know how this works, 9 times out of 10, it's a scam. The cops are just, what it is they'll search it, and if they don't find anything, they'll let you go, and they know most of the time you're never going to sue. So and then when they magically find it, it justifies why they searched it anyway.
Yeah.
Everybody can't smell weed, but cops smell weed when nobody else can.
Wait, lit and unlit are 2 different smells. I guess you know what they're not. Never mind. Discussion for another day. Kids are watching. Robert, the question is, what states have red flag laws, if any, and what's the status on the discussion of those? Because I know one thing. At one point I said, I like Dan Crenshaw. And then a lot of people who took issue with his position vis-a-vis red flag laws, because apparently he supports them, which I didn't know. But do any states currently have active red flag laws, and what is the status on that in the United States?
It varies all the way across the board. There's some cities that do, some counties that do, and some states that do. And some are being contested, some are not. Some died on the vine. When they were trying to push them, they failed. I'm sure they're going to come back and make a major push. But this is going to be a major constitutional hurdle to that. So the whole principle of getting around these was the idea that there's a community health exception to everything. That's what almost all these lockdown orders are based on. And what they shot down was, if there's no community caretaking exception to the 4th Amendment, why would there be a community caretaking to any other amendment? So that's why it was so critical that this decision come down this way.
Can you imagine? Community caretaking effectively means we can do whatever we want to take care of the community, even if it means violating your constitutional rights. It's a creative concept. I had never heard of it and didn't know how prevalent it was in U.S. law. The other question I was going to ask was, can you raise new arguments before the Supreme Court that you had not raised before the lower courts?
Generally, no, but they usually let the state and the feds get away with it.
Okay, because I figured it has to be the same thing here. Here, you can't raise arguments that were not raised in argument before the lower courts, nor can you appeal to facts that were not already adduced. And without mentioning the forbidden word, I did notice someone sent me a link. Apparently, they used on an IW clip yesterday. I don't know whose segment it was. Skinny guy talks very slowly, very clearly, unlike me. Had used my clip of the radio announcement telling you Quebecers, what you can and cannot do, what you are prohibited from doing. Apparently, other people found that as dystopian as I did. So that is done and done for. The only question is going to be what implications that decision is going to have on the other issues that it was touching tangentially. We'll see. Are there any red flag law decisions pending before the Supreme Court, or none really?
No.
Okay,
but it will impact probably 100+ decisions that are pending before various courts that had relied upon this community caretaking exception for what they did. So I have a very broad civil rights implication immediately, and then long-term because of how it influences not only red flag laws, but lockdown laws, all the policies based on some form of public health exception to the Constitution. This was a major shot across the bow on that provision, that a lot of governments thought this would be a big, huge loophole they could go through, and now not so much.
Okay, now a lot of people are asking about the Steven Crowder lawsuit, but I didn't know.
He hasn't filed one to my knowledge.
That he hasn't, and I just looked. He said he's filed a notice of intent to file an injunction. We'll see. Steven Crowder has mentioned a couple of lawsuits, none of which I've noticed coming down. The Facebook one, is it out yet or no?
No. And I think, they have some issues there. Usually there's mandatory arbitration clauses that are implicated, venue selection issues that are implicated. So I think that, I think he was gung-ho about the idea of it. I think it's his lawyer that's handling it, but to my knowledge, his lawyer's never handled one of those cases before. So it wouldn't surprise me if they thought one thing, dug into the research, and saw a lot of hurdles.
Yeah, because
kind of are in a wait and see mode. But he may not be long for YouTube. He got a second strike last week, so they're looking to kill the biggest independent YouTuber there is, because there's some other in the political space.
Yeah,
obviously there's PewDiePie and other people, but the independent political space, number one is Crowder, and apparently YouTube is out to kill his channel.
So, and it's not to say that he's not pushing envelopes. That's what he does, and that's what makes him who
That's who
he
he
is.
is. Yeah.
Yeah, but and it's like the idea is this the envelope that the pushing of which should warrant shutting down your channel? I would argue not in a free and democratic society, and not on a platform that is a free speech platform, even if they have their own terms of use and they're a private company. We discussed this on Friday with Eric on Eric Hunley's channel, but whatever. Private enterprise argument, we know the arguments for and against, but to my knowledge, everybody's, I think he filed a notice against YouTube, or a notice, whatever that means, but no lawsuit, nor on Facebook. And had he filed a lawsuit and gotten a change of venue because of a declinatory exception, we would have known about it. So, peeps, I'm following it. I admittedly was busy today and didn't see anything, but I didn't see anything because I don't think anything happened. No. Okay, one lawsuit that I think it'll be a good one to get into. Tabarouette. It was the tax one. Oh, the tax one. Texas suing the Biden administration for what are they? They're calling it unconstitutional constraints being placed on federal funding that the federal government is promising for COVID relief to Texas, Mississippi, and which other state, Robert?
It may have been Alabama that also joined it. Oh, by the way, Texas joined the Florida case against the CDC, to my knowledge.
Okay, yeah.
But the Texas sort of the lead on all this. There may have been a few other states that joined it too. Maybe Missouri, some other states.
Yeah. I mean, bottom line of the lawsuit, it's interesting because this is one where I can see both sides, and I can almost see the federal side more than the state side. But basically, the feds are rolling out a relief for COVID for all the states, and they're saying we're going to give you all this money, except we're not going to give you this money if you're going to use what we give you to put into effect a reduction in taxes on a state level. And if you do this, we're going to include a measure that allows us to claw back basically the correlative amount for whatever you've reduced on state taxes for the amount that you're being gifted, or not being gifted rather, but that's being given to you by the federal government for COVID relief. The idea, people, being the government's giving each state COVID relief. If each state says, well, thank you, federal government, we're taking this money, but we're also going to reduce our state taxes and, get 2 political wins, the feds are saying you can't do that because we're making that a condition upon which you can accept the federal stimulus money. And if you do that, we're going to come in and claw back some of that money that we've given you. The states are suing on the basis that it's unconstitutional. I forget the term they use now, but conditioning federal funding, coercion, basically coercing state action through federal monies. I don't know if that's a good enough explanation of the lawsuit. But Robert, I mean, explain why does that not make sense from the federal side?
It's the anti-commandeering doctrine. So it's the same doctrine that most cities were allowed to do sanctuary cities on immigration policy. And even when they, said, no, you can't under federal law, they sued, the feds lost. Same under the old doctrine, law that prohibited gambling within a state, sports gambling within a state. That was also struck down on grounds that was attempting to commandeer the state's resources. And basically under the 10th Amendment and under the legislative power combined and the interstate commerce limitation on federal power, the combination of those 3 provisions make it so that what the Congress can condition access to funds in a manner that directly correspond to what the funds are being spent for, as long as they are not coercive at compelling that behavior. And the problem here is it appears to be commandeering the states to not do something. It's not apparently related to the COVID relief package. Second problem. Third problem, it's too broad. In other words, they don't make clear, can the states not pass tax cuts now at all if they receive a single dime of COVID funding? Because that would be clearly unconstitutional. And that appears to be what they seem to be claiming, as opposed to saying, well, you can't use this amount of money to give a specific tax cut with that money. And that's not really what they appear to be doing. They appear to be saying, you take this money, no more state tax cuts, or we claw back the money. That would appear to violate the anti-commandeering doctrine under the same thing that the Democrats were successful with against the Trump administration, where there are some sanctuary city policies he could condition aid on, but in many contexts he couldn't. He couldn't be a complete coercive bar. I remember when I told people that back at the time, they were unhappy because they didn't like sanctuary city policies on immigration. Now they're liking sanctuary city policies because of the Biden administration. But, I agree with the 10th Amendment and that you can't command the states to do something. You can condition them, but you can't be unconstitutional conditions. And that's what appears this is. If they'd made it more limited to say this amount of money for these businesses cannot be used for this kind of tax cut for those businesses for X reason, then they would have been in cleaner territory. Risky, but cleaner. But that isn't what they did.
And I think we actually have to go into the sanctuary city lawsuits and flesh those out so people can understand, including myself. I remember this. I was still politically unaware at the time. Trump saying, if you don't impose or if you don't enforce federal immigration laws, we're going to cut off, I think it was all federal funding or something along those lines. So
police grants, law enforcement grants, things like that.
Okay. And now I remember the threat and I don't remember the outcome. So ultimately in court.
Yeah, they sued and they won. The states, the cities and states sued and won because Trump doesn't have that power. What he could do is he could say, I'm going to give you $5 million for this. But unless it goes for enforcing federal law in this context, I'm not giving you the $5 million. That he could do. What he couldn't do is say, I'm not giving you any money or I'm clawing back money unless you do what I tell you to do, because that's commandering. That's the difference. It sounds tricky. It sounds gray, but it's not too tricky and gray if you think it through. Are they coercive, or are they just saying we want this money to go to this and it's correlated to the policy? That's really what it is.
Great. Now the jokes are going to come out in the chat.
Yeah, exactly.
Let me see. I missed one from Carol. Carol W. said Air Force Lieutenant General Stephen Whiting, the head of Space Operations Command, fired Lieutenant Colin Matthew Lohammer from his post. Any legal recourse? Okay, I'm not familiar with that story. And I don't know why I didn't see that chat. Sorry about that. Now there was one that came from Beavis Wallace. From McAllen, Texas, the $300 per week federal unemployment assistance Congress approved earlier this year will stop flowing to jobless Texans next month after Governor Greg Abbott said Monday the state is opting out of the benefit.
Yep. The reason for that is that the unemployment benefits are so substantial that they're discouraging employment, is the Republican belief. You can argue whether that's true or not, but that's why Republicans are doing it. And so because basically right now you get paid more to not work than you do to work in certain industries and certain jobs, is at least the concern. Whether that's true or not, one can argue, but that's the core of where he's at. And he has the states have the legal right to opt out of things like that.
All right, now I'm going to bring this one up, Robert, because we had a discussion about this. Cleopatra561 says, it was a spirited day on vivabarneslaw.locals.com today. Israel's right to defend itself. Most people agree Israel has the right and is not the aggressor. Look at skynewsaustralia.com today for only right news on the subject. And Robert and I said, there are some subjects where there's law and politics, some subjects where there's just law, and some subjects where there's just overwhelming politics where it's never going to go anywhere good. So I said, that discussion, we can have that on Locals on YouTube tonight. We'll stick to the law and politics, but mostly law stuff. And I got a couple of emails and messages about the lively chat discussion. It's just a discussion. You know the way it goes every single time. I would say that an analogous thing that happened to me once when I was studying philosophy, and I thought you could have a philosophical discussion on Schmortian issues at a house party. You can't. Don't. It just ends in tears and you end up going home not fully appreciating what went wrong, but just knowing something went wrong. So.
That might be a good transition into the Supreme Court did take up the Mississippi abortion law case. And what the case is going to Mississippi passed an abortion ban after 15 weeks. With exceptions, but limited exceptions to when you could get an abortion after
those exceptions. Weeks. The exceptions, I presume, are rape, threat, risk to the woman, risk deformation of the baby.
No, it's more certain public health risks to the woman.
Okay,
not really specific to those other ones because the belief is you could get the abortion prior to the 15-week time period. Okay. So the main issue they're challenging is right now. There's an interpretation the lower courts gave in this case, which was that any law that restricts abortion prior to the viability of the fetus outside of the womb is presumptively unconstitutional. Is what they argue. And they're arguing that legal principle no longer makes sense with the existing medical knowledge. So there's two main questions that the court will be facing. One is, when is someone a person, or legally in this context, when does a state have a strong interest, a compelling interest in the life of the fetus? And the second one is, who decides that question? In other words, maybe it's not for the court to decide that question. Maybe it's something that the states should be able to decide on their own. And the Mississippi's argument to the U.S. Supreme Court is that they should revisit the viability doctrine, that any pre-viability abortion limitation is presumptively unconstitutional, that they should just scratch that altogether. Instead, say that the state, with the modern state of medical science, that states have the right to make their own public health determination once the fetus reaches a certain stage of sentient awareness of pain, neural capability, brain activity, etc. And that reflects sort of the developments of, we know a lot more about the mental and physical state of a fetus now than we did when Roe v. Wade was decided in 1973.
Now, this is one of the ones that I was not able to read. Who's filing the lawsuit? Which is the party filing the lawsuit?
That's the other question. Abortion providers sued the state of Mississippi after the law was passed. Mississippi is challenging their standing to sue. Now, people know, even though, people may perceive I'm on the pro-life side of the equation, I disagree with the state of Mississippi on this because, like I say, in all standing cases, standing is a bunch of gibberish and is just a made-up, invented doctrine, and I apply that no matter who it benefits or hurts. So, but that is the second part of the state of Mississippi. So the state of Mississippi was sued. They lost in the district court. District court said, no, this is a pre-viability abortion ban, presumptively unconstitutional. You didn't overcome it. Law unconstitutional. Went up to the federal. What circuit was that? I was going to say, I thought it was the Sixth Circuit, but I'm not certain. The came in and affirmed the district court decision, and they petitioned the U.S. Supreme Court to take it. The U.S. Supreme Court's been dodging abortion cases now for a while. They kept dodging this one. They kept bouncing it. Now, I mean, they weren't saying no. They just were bouncing when they were going to. And then today they announced they were taking it. And my guess is it would not have been taken. This is an area where, for those that are on the pro-life side of the equation, or on this side of the equation in terms of states' rights or however they perceive it, where Barrett was probably an ally. My guess is that Barrett is indicating that she will say that the pre-viability abortion ban being presumptively unconstitutional did not make sense and doesn't and won't going forward. And that they will likely say there's a compelling interest in a fetus life, probably from at least the 12th week onward. And this kind of reflects also a lot of international law. And international law, there's a lot of places where the first trimester abortion is very legal. But after the first trimester, a lot of places do not make it very legal. So, and this includes people that are considered liberal democracies in Europe. So the smart thing that the pro-life community's done is they've brought in the medical science. They've labeled some of these bills heartbeat bills, things like that, things where there's a lot more public sympathy. The public opinion generally favors abortion rights in the first trimester, generally is conflicted about the second, generally opposed in the third.
Yeah.
And so that's, I think now people that think they're going to say reverse Roe v. Wade entirely, and say that in fact there's a right to a personhood from the time of infertilization, I think they're wrong. That I don't see that happening, even though there's a strong Catholic bent on the court, and that's the official Catholic Church position, that life begins for personhood purposes under the 14th Amendment as soon as there's infertilization. Generally speaking, the courts haven't gone in that direction. I don't see them making that dramatic a move. Though, again, Kavanaugh and Barrett do come from religious conservative constituencies, as well as Gorsuch. Thomas and Alito have already hinted at they would overturn Roe v. Wade. I don't think Roe v. Wade will be fully overturned. I do think they will overturn. I think they will start saying that second trimester onward, you can completely ban abortion in most circumstances.
Okay.
And
now,
whatever you think about that, they'll say states have the right to do so, not that the states have to do so.
Okay, that was what I was going to say. So, I mean, the ultimate outcome in this would be to strike down a portion of this particular law, and then
I think they'll affirm this law entirely and reverse the lower courts. But that doesn't mean they're saying every state has to have Mississippi's laws. They're just saying states can pass Mississippi's laws.
Okay, interesting. And that is now the Mississippi law itself outlawed abortion after 15 weeks.
Correct. With one or two exceptions for like some form of health, and there was another one too.
Okay, now the 15 weeks, that date is, I forget what the
medical literature. 15 weeks.
What the youngest viable premature baby has been born at. Someone in the chat can help us, because I know it's
no. They don't tie it to viability at all. They wanted to challenge the viability argument. They're acknowledging that this is not tied to viability. Instead, it's tied to brain activity, sentient activity, the ability to feel pain outside the wound, as well as the heartbeat and organs.
Okay. I mean, this is another one of those debates where extremes on both sides, but when you hear some of the extremes on one side, and I think it was Norfolk, was it Governor Norfolk talking about
we put the little babies and we swaddle up the little babies, and my good friend does a very good imitation of the governor. Dear Governor Blackface.
No, this is where when you hear some of the extremes, and where you hear where that slippery slope can lead, and when you learn about other industries which a lot of people don't know about, and when you learn about certain things, it will cause you to question things that you might not have otherwise questioned. But that's interesting. So time frame again for these things with the Supreme Court. They've agreed they're going to take it up, hear it, and render a decision by end of the year.
You don't know. I mean, because normally, but what happens next is briefing. So both the merits briefs. You first file your petition for cert, begging for them to take it. Then they afford merits briefs. I'm sure there'll be tons of amici briefs on this on both sides, all sides. And we'll see how many they take and accept, but they'll probably take and accept a bunch. And I think the broader belief that it's going to overturn Roe v. Wade is likely mistaken. Not impossible, but likely mistaken. I think they're going to come in with what's been become the international norm but I think they will scrap the viability standard. The only reason to take this case is if they were going to scrap that standard. And I think they are going to scrap that standard. But I think they'll establish a new standard that gives states the rights to limit abortion from the second term onwards, because that's what this really poses, from the 15-week period onwards.
Well, I mean, it is. We've discussed the apparent contradiction in certain concepts where states that have robust abortion laws or very lenient abortion laws also sometimes recognize murder if something happens to a pregnant woman.
There's a lot of legal confusion in this space. I mean, similar there is on, age-related issues. There's a lot of legal confusion. One minute we treat somebody as an adult, the next minute we treat them as a kid. There needs to be legal clarity in this space. My view is, or what I think is the correct constitutional doctrine, is that states should have the right to be able to limit abortion and from the second trimester forward. That's my own personal view. I do think this court will actually come to that same decision because sometimes they make the right decision.
And the one thing we might want to do for another day, if it's too long now, is actually go over the Roe v. Wade in some detail, because I think it's among the more. It
was a crap decision. It was deference to the white lab coat crowd. It was not well rooted in constitutional law. Now, I don't agree with some of my conservative friends. I absolutely believe the Fourth Amendment includes a right to privacy. I mean, that's just nuts. To me, the question has always been, when is someone a human person? Because then you have two different lives at stake. And you have to deal with that meaningfully. And my own view has always been that we should count life and death the same. And right now, medically, we consider you dead when you're brain dead. So once there's real brain activity, how do we not call that life when we call it life before we'll allow someone to be declared dead? That's my own view. Though I do think I've always viewed that this should be a state issue. This should not be a federal issue.
Okay, well, I was going to say, so maybe one day I might just do a video breaking down Roe v. Wade in not meticulous detail, but people could be well served to know the details. But getting to our one day O.J. Simpson was innocent stream, Robert, no guarantees, but it might be in the works. So everyone who says we've been putting this off and dangling it like a carrot that's on a stick that you're never going to reach, we're going to reach it one day. It's just a question of the modalities, whether it's just Robert and I, or whether or not there are other guests in the stream. So stay tuned, everybody, because it is in the works.
Yeah, I polled our locals board, Viva Barnes Law, locals.com. And turns out, my views on Israel, Palestinian conflict, my views on Michael Jackson, my other crazy views, those were not considered nearly as crazy as my theory that the OJ verdict was the right one.
Oh, I'm getting some not flack. I'm just noticing some very stimulated comments on the Michael Jackson highlight from Razor Fist, and I got an email. I mean, people email me. They're emailing me about Michael Jackson. It's not to make light of the accusations. It's just like it's a celebrity accused of these things. It's very weird how people who are not personally connected are personally and emotionally vested in what happened to Michael Jackson. Some because he's a fan, and others because they think he's a villain. But I swear to you, I had no idea a highlight would gain that much traction and that it would stimulate that much discussion. But yeah, what I also love is you are among the most intelligent people out there, and nobody's going to deny that. But the second you say something that people disagree with, you become a villain and all of your intentions are evil. And when it comes to O.J. Simpson, it's not that you have an opinion and people can disagree with you. It's that everything you've ever said has to be wrong because people cannot understand how you believe that. And I will only say, I still believe O.J. Simpson is guilty. I believe it. But when I did find out during the stream with Dershowitz that the cops took blood out of a vial, planted it on his sock, and then tried to run that off as evidence, guilty or not in my mind, that can warrant an acquittal in law because you don't have to frame a guilty man. So
yeah, trust me, it gets much, much, much worse when we dig into it.
We're going to do it. It will happen, everyone. So it's just a question of the modalities. Let's see. Sawaz says there are 3 locations in Canada that offer abortion up to 23 weeks and 6 days. No providers in Canada offer abortion care beyond 23 weeks, 6 days. I can say I don't know. I actually don't know if
abortions are rare, but they do happen in parts of the United States.
Okay, well, that's an interesting one. What is the next one that I did not read up on, but I can only imagine it follows the same lawsuit, the farmer lawsuit. The bar owners suing for discrimination in Biden's COVID relief plan. You gotta present it, and I'm gonna ask you some questions as you go.
Well, Biden didn't limit his critical race theory application to not to removing the lawsuit that had been filed on behalf of Asian Americans in the Justice Department against Harvard, which he killed from going up to the Supreme Court. Then he basically made farmer aid almost limited as much as possible to minority farmers, even though they are a tiny percentage of farmers. But he also created a bunch of money passed by COVID for restaurants and bars, but then said for the first 21 days, the only people that can apply are specific categories by race and gender in particular. And it looks like all of the money is just going to go to them because more money was requested than is budgeted, such that if you are white and if you're a white guy and you own a restaurant or bar, you can't get any money, period. Zero money out of COVID. So the America First Legal Foundation, founded by Stephen Miller, has filed suit in Texas, in Fort Worth Division, where on behalf of a bar owner who lost over $100,000. And they're saying, look, this is simple. This is race and gender classification. It doesn't relate to COVID relief. There's no correlation to it. There's no factual findings to justify racial and gender disparate treatment. Discriminate. This is over. This isn't disparate impact. This is saying white guy need not apply. And the point is that violates the Fifth Amendment to the United States Constitution and has violated our laws since the Fifth Amendment to the U.S. Constitution, is recognized at least since the 1960s. So in my view, their suit should absolutely prevail. And I'm curious. It's a scary precedent. They're trying to create a precedent where they can just say only this group or only that group by race or gender. Someday they'll expand it to religion. And like I say, ultimately they'll extend it to politics. Only people that can prove not only they got vaccinated, but that they voted for Joe Biden can get the money. Because that's what it appears often that it's about.
It's so depressing and irritating. I did a podcast today with a Canadian comic who's got a great podcast called Pantelis. And we're just talking about how divisive the politicians are with their rhetoric and with their policies. And is there anyone in their right mind who thinks that this is going to do anything but sour race relations, cause conflict, cause tension among races as opposed to unity among races? It is the only person who might think that based on their positions that I've seen would be Mark Lamont Hill. I mean, people who in their minds, and they're entitled to their opinion, believe that there is only one way to remedy wrongs from the past, and that is to effectively call them wrong in the present or compensation in the present. But the idea that you would create this policy, everyone is suffering, and that everyone who is suffering are going to see some people suffering less based on, I mean, what's the rationale? The rationale can only be historic injustices that can somehow explain why certain people are hit harder during a pandemic than others, when effectively everyone has suffered pretty much equally, except, everyone based on industry has suffered pretty much equally, not based on race or privilege. And you impose something like this, the only thing it can do is make people look at each other with a stink eye and create tensions among society. And then to try to cloak it, because in the farmer's case, it was overt, but here you're saying, well, I guess the rationale here is the defense is going to be, we're not discriminating, everyone's eligible for it. It's just going to happen that I guess if people apply first, there's going to be nothing left whenever other people are going to apply. I mean,
well, it can't, because the only people who could apply first were those groups. So so it's the same. Can they overtly discriminate by race and gender and distribution of funds without even a factual finding justifying the policy rationale? It's a terrifying place that they're going, and the media is just mostly suppressed news of the story.
No, the media is not going to. They've been promoting the same narrative. They're only going to either support the effort by not reporting on it, because maybe I see things in a naive perspective, but if I am of the minorities that would even be favored by this, I would not want it, because this is going to create animosity. It's going to create stigmatism. And again, it's a little bit more of the soft bigotry of low expectations, as if to say everyone is suffering under these government-imposed restrictions, which is interesting enough on its own. Everyone's suffering, but some people need more help than others. I mean, that's basically it's nothing more than saying that people who decide to smoke menthol because they happen to be majority black need protection from the government, and other people need extra support from the government because they can't do it on par with everyone else who's suffering equally. Terrible. I mean, prediction, I can't see it succeeding. I'm shocked by the attempt in the first place.
Yeah, I mean, I assume the courts will knock it down, but it's kind of terrifying that it even exists in the first place. But hopefully the courts will knock it down. Say you can't do things like this in such an overt and open manner, but we'll see.
Okay, well, what do we say? I mean, it's one of those decisions. Yeah, it's one of those suits, which is just, it seems that it should be clear on the law, but it's in your face. It's in your face at this point, and there's no relenting to it. How about Project Veritas? I mean, we can. That's another good one. For anybody who doesn't know, they've been using my clips in their videos, and I love it. It's fantastic, and we're still in the works. We might be getting a good sidebar sooner than later. Project Veritas. Did we talk about it last week, Robert? We didn't talk about it, did we?
Yeah, but the only thing we didn't talk about were the admissions.
Oh, well, the admissions. Well, the admissions of fact that it was not opinion pieces, not written in an opinion section. The admission that the New York Times was effectively not following its own ethical standards for journalism, and I guess the admission that Maggie Astor was in fact, by working with an embargoed report from the Election Integrity Program, EIP, by working on an embargoed.
I mean, it was some Orwellian named group.
The admission is that she was working with an embargoed copy coming from this EIP, Election Integrity Policy, whatever, the report that they produced. They coordinate their release of the news to demonize and defame Project Veritas when they're the ones who basically were in a coordinated disinformation campaign. What do you make of the admissions, and how far do they go? Can you take those back?
Well, I think it's the utility of these kind of suits. Like, people often get caught up in whether or not you win the ultimate outcome. And I think that misses the boat frequently. So, like, you look at Florida against CDC, I think the mere fact they sued got the CDC reconsidering and reevaluating what their policies can be in general, including on masks and other things. I think that was part of that response was, oh, wow, we're about to face a bunch of lawsuits, and we really can't win these if they look at the factual merits. Here, the same thing, just by filing suit and getting past motion to dismiss stage, they're forcing the New York Times to respond and answer and file legal pleadings in court that are binding against them, unlike motions to dismiss, which are not binding against them. And they're having to make admissions and confessions. And here they're making critical admissions that they do have these ethical guidelines they're supposed to be bound by, that they do list these people as factual journalists, not opinion makers, that in fact that they were corresponding and conspiring with people like was suspected, in some cases even worse than was the case. That's critical information that he gathered solely because he filed suit and pursued it. So no matter what else happens, he's already won another critical stage of the case. He won a favorable ruling from a court that really said damning things about the New York Times. Now he gets admissions in court that really sets up that is helpful no matter what happens the rest of the case. So I think that's why it's important to support those kind of cases. You can have a smart strategy to pursue a case without your ultimate objective being to win everything. Like in the Covington cases, sued Elizabeth Warren knowing it might be uphill, and ultimately the court said, nah, you can't sue a senator, you can't sue a congresswoman. That's fine. Going to use that fact to get congressmen to start to support new laws that make it clear you can't do that anymore. You're not immune in that respect. What sets it up is the lawsuit. Without the lawsuit, I don't have any motive. I don't have any reason for any congressman to jump on board. So it's the same. Somebody asked about the state cases. Those are up on appeal because they're saying I can't sue in Kentucky. I disagree. So I'm going to fight that out. But that's the reason why you bring the suits where you bring them. You want to challenge a legal principle that has a broader impact on the broader population. And people focus on just whether you win or lose the case. That often matters, but there's often bigger impacts, bigger influences that you also should take into consideration. And that's why what Project Veritas is doing and continually exposing the New York Times is fantastic. And New York Times clearly was feeling the pain because they ran another hit piece this week on James O'Keefe.
Yeah, I missed that one, and that one I got to catch up on. But I'll wait for that to be another lawsuit on its own. What pees me more than anything in all of this, people still trust the New York Times, and people don't even know about this. And then you try to talk to them, and you try to explain to them, like, oh, what's the big deal? Because they already hate Project Veritas for reasons that they don't even understand or know. That they are willing to put up with this crap and just write it all off and utterly ignore it. This is like finding out that your watch is gaining a minute every day and then still continuing to wear that watch as though it's an accurate reflection of time. This is discrediting to the core of what the New York Times is. And the fact that people don't know about it or don't care about it leaves me somewhat discouraged as to the level of intellectual dishonesty of the people who rely on the New York Times. And I'm saying this, like, you can get factually correct stuff out of the New York Times, but this makes everything they have ever done suspect. And when it becomes political, it makes them entirely unreliable unless they're admitting something against them. And for anybody who's interested, I was joking about, can they take these admissions back? Judicial admissions cannot be taken back, but people need to understand what these judicial admissions are and how damning they are. What can they do to get out of a deposition, Robert? O'Keefe is not going to settle. What can they do to refuse to produce the witness that O'Keefe is going to want to depose?
They're not going to be able to. So, I mean, what you're seeing is, them doubling down on some of their aggressive, counter-aggressive postures while they lost at the motion to dismiss stage, lost really at the answers admission stage. They're going to lose at the discovery stage, and that will probably be the most embarrassing of all. And I think they're in a kind of denial about this. And so consequently, Project Veritas, I think, will continue to accumulate wins just by being able to proceed to the next stage of the case.
Well, the depositions and communication of undertakings, whatever you call it in the States, is going to be glorious. Because you don't think that there's going to be damning emails between Maggie Astor and the EIP? Like, these reporters say stupid things in public on Twitter. They probably don't think about weighing their words in emails, always in cash, never in writing, Robert. Gotta get that one up. And by the way, incidentally, so Tom Villa says 13.4% of your viewers are on Rumble right now, and I just looked, and we're at 1,170 on Rumble. So that's beautiful, because that means, A, we're over 8,000 live, and it's a Monday night and the timing's off, which is one thing, but beautiful that we're getting to Rumble. And Rumble, apparently big news coming out, but I don't know what it is just yet. What do we talk about now, Robert?
The state of Mississippi overturned its pot referendum.
Oh yes, yes, yes. Okay, go. You're gonna another one. You're gonna have to field because my knowledge is minimum on this.
Yeah, I only know a little bit about it, but it's basically the Mississippi Supreme Court not allowing the referendum to go through on various grounds. I don't know what all the grounds were. I can say that in general that there's been a history of judicial hostility to referendums and initiatives that I think are problematic, but I haven't looked enough at the underlying briefing on the Mississippi Supreme Court to issue more detail, but it's problematic for a bunch of referendums in Mississippi. So we'll see how it comes back around. But there's a long history of judicial hostility to referenda. California, they litigate these all the time, and so not a major surprise that Mississippi's Supreme Court would step in this capacity. But I have questions and doubts about their basis to do so. But because I haven't read all the underlying briefing, I don't have a detailed opinion on the subject.
Let's do another Canadian one that is of interest to me and might affect me particularly, but is also of interest to a free and democratic society. Our Bill C-10. I've done a bunch of videos on it, but it's worth stressing and it's worth going over some of the new developments. So in Canada, we have this thing called the Broadcasting Act, which is a law that basically created the Canadian Radio Television CRTC Telecommunications Commission, which governs everything that is aired on television and radio, creates requirements such as diversity, Canadian content, a bunch of things, like quality control. But basically, the idea of the quality control, the idea of the Broadcasting Act was to benefit the Canadian culture, heritage, and economy by, if people come to shoot content here, they have to meet certain requirements in terms of hiring Canadian actors, et cetera, et cetera. It applied to radio and television. Given what's happened to streaming, the government says we're missing out on an entire market, the Netflix, the Hulus, and whatever online. We want to expand the Broadcasting Act to govern broadcasters on online interweb stuff. Fine. Think of it what you will. I think the idea of this law in and of itself is suspicious and bordering on propagandist, but whatever. I'm not sure how much it benefits as opposed to deters people from coming here to shoot films, but whatever. They, in the Bill C-10, which was an act to amend the Broadcasting Act, they said the concern was that this was going to apply online and it was going to sweep up in it individual content creators, user-generated content. So they included an exclusion in the law which says this is not going to apply to user-generated content. The Liberal government, under the cloak of darkness again, removed that exclusion from the law and basically turned this law into something that would potentially impose on individual content creators on their social media platforms, on the interwebs, the requirements under the Broadcasting Act in all their glory. And that's where we are. Now, you have Justin Trudeau coming out under cross-examination from the brilliant and always annoying Pierre Poilievre. And Pierre Poilievre, I say, is annoying because he reminds me of my oldest brother when we used to debate when we were kids. He was smarter than me at the time, and he had a meticulous way of picking apart bad arguments and, trying to get the fool to look foolish. So Pierre Poilievre is, attacking Trudeau again on this. Trudeau comes out and says, this law is only intended to protect content creators. And the reason why the exclusion is not there anymore, because we want to sweep up the content creators, because this is intended to protect music creators and content creators. At the same time, you have the Canadian Heritage Minister, Stephen Guilbeault, saying the exclusion was useless because we never want to target individual content creators. Unless you have a big enough following, then and then you're acting like a broadcaster, then we want to go after you. And so that's where this bill is at. And this bill looks like it's going to pass because it has the coalition support of the NDP. The Conservatives who oppose it don't seem to have enough power to block it from passing. If this bill passes and its impacts are what people fear it could be on individual content creators, well, ... to that. But that's the biggest Canadian thing. And again, Robert, from the States, we're living through crazy times. But what do you think when you see the government basically saying we want to impose on individual content creators potentially these stringent applications of this Broadcasting Act, which do you have the equivalent of something like that in the United States?
Well, the FCC at times has tried that, but they've been denied the ability to do it. So, our First Amendment is just much more robust. We legally, the U.S., the free speech is stronger in the United States of America than anywhere in the world. And that presents a good transition. A disturbing case to watch is the Ukrainian government is now going after its political opponents and charging them with high treason for basically being their political opponents. And this is after they shut down a bunch of broadcast stations they didn't like. And the U.S. media is completely silent about it. The Biden administration is completely silent about it because they support the regime in Kiev that got put in there and that in part owes their legacy to the Maidan Revolution of 2014, which was a coup by the U.S., largely backed by the U.S. But one of the people, for people who don't know, there are some people who may be familiar. If you've watched Ukraine on Fire, either the first or second one by Oliver Stone, that one of the main Ukrainian people he interviews is the guy being charged with high treason, mostly because he's friends and been long-standing friends with Putin. But it's just overtly political prosecutions, some of the worst I've seen anywhere in the world. And unfortunately, the Human Rights Watch and all those groups that get up in arms over certain places in the world are suddenly silent when it comes to one of the most politicized prosecutions I've seen anywhere, which is going to be taking place in Ukraine. So that will be something to watch from an international rule of law standard and politicized prosecution evaluation as well. In the same capacity, we had another example of that with the officer who apparently was fired, who gave money anonymously to Kyle Rittenhouse's fund. And so he is going to be bringing legal action based on that this was an illicit firing, both for free speech and due process reasons.
Yeah,
so he should win that suit, but the suit hasn't been filed yet.
When that suit is out, people, when that suit is out, tweet it to me, message me. Robert, if you get it, send it to me. I'm on that one because that one is one that particularly irritates me just in terms of any rationale explanation. When I first heard the news, I just assumed that the officer did it publicly through his professional account, in which case I still wouldn't agree with it, but I could understand it that they don't want it to look like formal policy. But to get hacked and to have used your work account anonymously just because, it's egregious. It's almost as bad, and I'm pulling up a tweet, as unsealing anonymous Twitter accounts. Now, Robert, I didn't know about this. Eric Hunley, who also is on Locals, erichunley.locals.com. Unstructured.locals.com. And we go on Eric's channel often enough. It came from Kay Poulsen, who is investigative journalist and data geek Wall Street Journal. This was just unsealed. In the last weeks of the Trump administration, William Barr's Justice Department tried to use a secret grand jury subpoena to unmask an account at Nunes Alt, a Devin Nunes parody account. What do you know about it? I mean, I skimmed through as quickly as I could, but what do we know about this? How politically motivated was this? And how atrocious is this?
We'll find out. I mean, some of these, I suspect that some of these were Justice Department people that are on the Trump side of the equation that had a wide range of concerns about a wide range of issues. And so that would be my assumption. The other thing is, like, there was talk that there had been searches of journalist information. Some of that may have been under Sessions when he was looking at who illicitly leaked FISA and other materials concerning Flynn and others to the press, which would be a legitimate inquiry to make. It didn't appear to go anywhere, that's for sure. So we'll have to see how it plays out. So far, a lot of those stories along those lines have not led to where the media originally said they were going to lead. So I'll wait and see whether somebody did it for politicized purposes and whether it broke certain rules or not. But Mueller, the same media people, aren't talking about the fact that Mueller was subpoenaing Twitter and other records of almost anybody connected to Trump for a year. And I didn't hear any of these people raise a whimper. So I'll believe their sincerity when I witness it.
And I may have just violated my first rule, which is that typically the initial reporting doesn't go exactly how the initial tweet or reporting. The ultimate reporting doesn't go the way the initial reporting did. There was a legal proceeding attached to it, which I should read. And if it's worthy, maybe, if it's interesting enough, do a video on it.
Speaking of which, apparently, I don't have a full update, but apparently Legal lost some more in court. That's what Legal does well. he loses.
On the
That's what
FOIA
the L
request.
stands for in legal eagle, loser.
Well, I'll tell you what it stands for. I was noticing his numbers, 1.88 million subs, and I swear to you, this is no jealousy whatsoever. It is nothing. Period. I wish success on everybody. It's just what's interesting is I was charting everybody's numbers over the last little while, and it seems, politics and the election cycle over, a number of the law channels have stagnated to some extent. Not all though, but it is.
I mean, YouTube. This is who YouTube promotes as of legal knowledge, a fountain of legal knowledge. And like I said, Legal Eagle was the kind of kid who didn't qualify to ride the short bus to school. So.
And you get flack whenever you say that, Robert. But it was on the FOIA request lawsuit. That's the only pending lawsuit that I know.
I haven't looked at it yet, but someone just gave me the update that he lost some more again. Not terribly surprised, but we'll have that update sort of next week. People had asked a lot about the vaccine-related lawsuits, vaccine passports. I'll have more of an update next week when I anticipate some suits start getting filed, because we're still waiting for some information.
And I mean, we're now going through these issues in Canada where,
they're expanding it up there.
It's our prime minister, yes, Justin Trudeau, literally just said we're looking at vaccine passports to make it easier to get certain services and better services. I screwed up the passports. And now you have the discussion, and if you take issue with this, they label you as an anti-vaxxer, and this is how the discussion gets framed. It's like,
and now the FBI voluntarily threatening everybody that if they have a false vaccine identification, then they'll call it federal crime. And it's only there's no specific federal criminal law that applies. So it would only be if you presented false records under penalty of perjury to a federal agency, something like that. But otherwise, it's a broad stretch to say that any form of identification that says you were vaccinated when you were not is necessarily a violation of federal law. That's not clear to me at all, but it gives you an idea of where they're heading.
Let's see what we got here. Alex David Duke says, David and Robert, mandatory vax for education workers at public schools. Can this be enforced in USA? Fed law prohibits.
Because it's not while it's an emergency use authorization vaccine. And I'll get into more details of this next week. But the short answer is that most of these places are actually, if you look in the small print, they're making reasonable accommodation. They're saying you don't have to come on campus or something else. And in other contexts, they're actually waiting for the rule to go in force until the FDA approves it's no longer emergency use. So that's part of why I'm waiting. We're waiting to see what the actual policies are from these places before we bring suit, because that will influence the shape of the suit.
Someone says, Chance Schofield says, Styx said it was people reproducing the government seal. I mean, I guess that would be one.
But only if certain apply. Like, for example, there's fake currency. You play with that with Monopoly, right? That doesn't violate federal currency laws. You have to try to pass it as federal currency generally. So, I mean, just the fact that you have something with a government seal, with a government trademark, with that maybe look like a government record, until you do something with it in certain contexts and certain places, it's not a federal crime. I mean, remember Arthur Anderson, when they found out they were going to be audited by the SEC on Enron, they went and shredded. U.S. Supreme Court said that can't be obstruction of justice, all right, because they hadn't got a subpoena yet. Why? Because it's about federal jurisdiction. There has to be a certain action, a certain context, a certain place. You're producing a record under a certain penalty of perjury, so forth. Otherwise, everything is not a federal crime like they try to make it out to be.
Oh no! What I was just going to say, to add to this discussion where they demonize, and when I call into daytime radio, when I get angry at what I'm listening to, they actually ask as one of their filtering questions, "Are you an anti-vaxxer?" And I'm not. No, but you have Justin Trudeau at one point saying the best vaccine for you is the first one that's available, and then when the news about AstraZeneca and Johnson & Johnson come up, he's not singing that tune anymore. And so he has made himself an anti-vaxxer. And yet, and it's, you get demonized and labeled anti-vaxxer, extreme right-wing, whatever, extremist, because the news that comes out keeps coming out. And it's enraging. I don't know what's going to happen in Canada. We've seen what the courts have done already. I don't know what they're going to do about these types of lawsuits if and when. There's a lot of deference to the risk, the perceived risk, and I would say to some extent the exaggerated risk. Okay, and then we got Sad Wings Raging. Show me your poo flu paper. Okay, and there's a discussion about falsifying passports. I mean, I would anyway. No comment. Robert.
Well, I mean, some people might just identify as being vaccinated. If you can identify as a woman, why can't you identify as being vaccinated, even if you're a man?
We've been married for too long, Robert, because I was literally going to the transgender lawsuits as to whether or not there have been any developments in the transgender lawsuits filed in the United States. I don't know which ones are out there pending. I just want to loop this into Sarah Silverman. Has there been any? Have there been any updates on the transgender lawsuits in the United States?
I think they kind of lost the Connecticut one initially, but I think that's going up further. But that's the only update I've heard so far.
Connecticut,
the idea that men should compete in women's sports, is kind of crazy. But you see how political it is that if a transgendered person says a man shouldn't compete in women's sports, that means the transgendered person is transphobic.
It's everybody has got to go watch that video from Sarah that I did on Sarah Silverman, because it's the level of, I don't want to call it pomposity or arrogance or condescension that Sarah Silverman, in her capacity, thinks that she's in a position to demonize Caitlyn Jenner, who is a trans person, who was I never knew I guess I don't know how you say this, but in his previous life was the world's greatest athlete. I had no idea.
I used to have his book. I used to have the book. I used to have let me put it with YouTube correct terminology. I used to have a book authored by a man named Bruce Jenner, which was all about, he's one of my icons. So Caitlyn Jenner was once Bruce Jenner, according to Caitlyn Jenner. So I think that's all politically correct language. But yeah, great athlete, great athlete. The world's most famous transgendered individual says, no, it's obviously an advantage for transgenders to participate in women's sports, and it shouldn't be allowed. We should protect girls' sports as biological girls' sports as a separate event, because that's the only fair thing from a sporting perspective. This is Joe Rogan's position. It's not anti-trans. It's respect for girls' sports, biological girls' sports. And it's amazing that Sarah Silverman, Caitlyn has become a, man, I'll get into trouble in this thing quick, but Caitlyn will get, Caitlyn, I'll stick with Caitlyn. Caitlyn, says something that is a heresy in the Sarah Silverman, Sarah Silverman of blackface fame, Sarah Silverman of I'm going to watch Louis C.K. do what Louis C.K. is doing and think it's okay fame. Somehow she is supposed to be the spokesperson, the priest, the high priest of what is morally virtuous and socially okay.
No, and she said transphobia, full stop. It's not about protecting girls' sports. And the examples she gave, on the one hand, they were I don't want to say dumb. They were just superficial to the point of absurdity that what about tall girls versus short girls, or different weight class. I think she actually said weight classes without fully appreciating that there is a reason why there are weight classes in certain sports where weight is a determinate factor in not only performance but risk, and discriminating against trans people where the trans issue of their identity is irrelevant to the aspect of the discrimination. Yes, it should be illegal, unlawful discrimination. Where it plays a material factor in the aspect of the discrimination in terms of strength, performance, it should be as legal a distinction as a bus driver who can see, is the analogy that I use. You're not discriminating against the individuals because of the aspects of their identity. You're discriminating in the sense that it impacts performance in a material way. People in the chat can help me. There was a UFC fighter, and I wasn't fully aware of this either, a trans fighter who cracked a female fighter's skull. And it's just so obvious that you're not being transphobic, but you're protecting women's rights in a way that is not invasive or not disrespectful to any other person's rights. And to try to frame it that way, I don't know what traction it gets. That's the thing. Like I noticed there was a lot of, I think she got ratioed on the tweet, but I don't know that people actually buy into this reasoning. And I hope they don't, because it's just
Richard Barris did a big poll on it. public opinion polling project, and people overwhelmingly reject the idea that biological men, even if they identify as women, should be able to compete in women's sports. Overwhelmingly. They like, for the same reason you have weight class differential, you should have biological based differences. And that isn't being anti-male, female, trans, or anything. That's recognizing substantial differences to allow people to compete. I mean, if we only allowed one level of boxing, it would only be heavyweights. You know, we would never get to see flyweights and bantamweights and lightweights or anybody else because they would all get killed. So, I mean, that's why we have different weight levels, is the same reason we should have different recognitions based on biological gender. And and that's a 75% opinion in the country. Very few people disagree.
No. I mean, I would venture a guess that the people who disagree are just never have never watched UFC in its season 1, where you had, I mean, a little different because there were no rules, so a lot of things flew, but where you just had things that were just made no sense in terms of the actual combat, and then it led to bad things, which led to rules and which led to restrictions on the one hand on weight classes and on moves. But yeah, I'd say venture that people who take that position are taking it from a purely moral position without any experience in combat sports or sports where genetics and XY, genetics, not a gender identity genetics, it plays a material role, and it's a question also of protecting women physically in these sports where it can be disastrous. Cleopatra says, people would like to hear what happened in Maricopa County. Please, Robert, what is the update?
Not much of an update, other than it appears, I mean, what was confirmed with the sidebar with Razor Fist, he's from Arizona. So even though he's a cultural commentator primarily, he also follows politics, sort of grew up in the talk radio space or wanted to be in that space. It was a fun sidebar. In fact, I went and watched Cobra afterwards, sort of, because I felt like it was appropriate to watch that film. And I remembered how, that's another Rotten Tomatoes, 14%. That was a great fun film. That was awesome. But that little side point. But what he mentioned confirmed my understanding, which is they're not doing a meaningful signature match, Jack, which is unfortunate. But apparently auditors are reporting that they've already discovered substantial deficiencies in the way records were kept, including apparently, again, no conclusions yet because it's an ongoing process, but apparently a whole bunch of records were deleted. So apparently ballots were either destroyed or never properly counted because the ballots, the number of ballots are supposed to be in a box. They have these things called batches, and they report the numbers are not there. They're finding other deficiencies. So there was a reason Maricopa County didn't even want a limited audit. It was because they were going to discover that our people would be shocked at how incompetent and inept our election procedures really are. And so it's already promising that it will reveal serious procedural flaws in our system. So I think the audit will turn out to be a good thing, even if it doesn't lead to the consequences some people would like, or audit some things I would like audited. I think the mere existence of it promotes the transparency necessary in election review, and it will produce some more information. But it's probably 2 or 3 weeks away from any audit report being finalized.
If anybody hasn't seen Razor Fists or chat, it was particularly fun. But I don't want to compare it to the other ones because the other ones are all great as well. It was just new for me because I haven't been able to revisit the idea of good old fashioned movies when they were violent for the sake of violence. Before violence,
I mean, just cool, and they were overtly they were proud. The way I put it, it was when films were had cojones and weren't castrated, and the sort of male persona, the certain male personality was reflected. And the reason why that's significant, it's politics is downstream from culture. When the Cobra characters disappeared from the big screen, is when suddenly men could participate in girl sports. That's not a coincidence, folks. It's the reason why we're platforming some of these folks and introducing you to some of these folks. There's a deep interrelationship. You may not think you care about film or entertainment, but you need to. That was Andrew Breitbart's point when he said politics is downstream from culture.
Yeah,
one of the questions from locals, like to hear about the abortion case. Well, we did address that. Whether Steven Crowder is going to officially sue YouTube. I've told his people I'm happy to help him out in whatever way, but to our knowledge, he hasn't filed suit yet. from who are the biggest. I'll save that for Richard Barris.
Well, Robert, you got to read the question. Censor if it's. Are we allowed?
Sure. Who are the 5 biggest GOP weasels right now? So that's a good but that'll be a good Richard Barris discussion. If people want my views on the Israeli-Palestine conflict or issues, you can watch the What Are the Odds from earlier today, or go to vivabarneslaw.locals.com, where if you want to troll me because you're on either side of that, you're free to do so. Somebody was upset that they thought they were going to be censored, and they're like, oh, and they're all man. It's like, no. I'll even respond to most of the critics. Now you can't go certain places. If you're just rude to be rude or mean to be mean, then yeah, I have the censor button, but I almost never use it. And you can disagree with me as much as you want. You can accuse me of being part of some secret agency or whatever. I don't. That's completely fair game. No problems.
Who were they, Robert? During our stream with Joe Kent, they were accusing him of being part of the CIA. I mean, I guess technically he was.
He had worked for the CIA.
Yeah, so that makes a little more sense. And by the way, follow him. Watching Joe Kent hit the pavement and post his updates on Twitter, it's inspiring. I don't often retweet politics because I don't believe in telling people who to vote for. Even if I run for office, I'm not going to tell people to vote for me. I'm just going to hope they would vote for the policies if they like. And if they don't like my policies, I don't want pity votes. But watching Joe Kent, it's inspiring to watch. And he's really.
Absolutely. And people would ask whether we were going to have more people like him on. And yes, we are. So this coming week sidebar is Ryan from Geeks and Gamers Outpost. So Ryan, I think it's Ryan K. Outpost. Another good cultural commentator coming up not long after that, or maybe even sooner, depending on timing, will be James O'Keefe, hopefully, and Salty Cracker will be coming soon. And hopefully, if everything works, Bobby Kennedy Jr.
Yeah, I was going to say, people are asking. I don't like I don't like mentioning names of the people we're working with and trying to get dates because I don't want to look like I'm using the crowd pressure to make them say yes or commit. So I also
I'm all in favor of crowd pressure. We got a commitment from the libertarian comedian
Dave Smith.
Yeah, Dave Smith, who was recently on Joe Rogan. I was like, hey, why don't you hop on? And he said yes, too. So we'll have lots of fun sidebars. We have commitments from people throughout the rest of the year. Amanda Milius, the writer, director, producer of The Plot Against the President, who worked in the State Department for several years under Trump. I know her, got the chance to meet her several years ago in D.C. She's committed to coming on. So we have a great list and litany of people coming up. That'll be a lot of fun, usually on Wednesdays, sometimes for their schedule on another time frame. And one person asked about UFOs. That's another definite. Richard Barris has a lot of interest in that topic, so we'll cover that there.
I can't understand why, even in the military, they don't have high resolution color images. I understand some of the technology that they're using, but surely when they spot the UFO and they're trailing it, like I saw in one of those videos now, turn on a color camera so I can see it. I can't make out the infrared or the black on white, but some of it looks amazing. It's mind-blowing, really. And the only question is, people immediately equate it with aliens and extraterrestrials. UFO just means it's unidentified. It could be some amazing technology that a small country has and we don't know about, but fascinating stuff. Let's do one more update from Canadian law. We are now, I think we're up to having arrested our third pastor. I don't know the name of the third one specifically. Someone can help me in there if you see it. But Pastor Artur Pawlowski was arrested. And arrested, Robert, in Roger Stone type, who was the other one? Steve Bannon, pre-dawn raid. Paul Manafort. They arrested Artur Pawlowski after he held unlawful service, pulled him over on the highway. I swear to you, there were more cops there. It's like you would think that there is no crime. We're in Edmonton, so you'd think there's no crime in Alberta with the amount of police they had. And admittedly, look, we're not blind. He was making a scene of it because that's what activist people who believe in their cause do. Wasn't making it easy for them to, put him into the police car. But they pulled him over on the side of a busy highway with 20 cop cars for maximum intimidation. Otherwise, you could have tailed him home and gotten him in his parking lot, arrested him in broad public. He's been released. And Rebel News is assisting with the defense. So Rebel News is a word, people are going to judge me for saying it. I don't care. Rebel News is doing God's work. For any of their foibles and for any of the things people don't like about them, they're doing what no one else in the media is doing in Canada. And it's helping people, fight for their rights. But that's it. Artur Pawlowski arrested. He's going to stand trial for, whatever the charges are against him. Pastor Coates, the trial started. I think we talked about it last week, but basically they're going to adjudicate on whether or not his rights have been violated. And then they're going to schedule a new hearing for June to determine if there has been a violation, whether or not the government has proven the necessity of the violation. And other than that, Canada is going the way of other regimes, and I don't like it one bit. And it seems that the only person who's out there hitting the pavement and hitting the crowds literally is Maxime Bernier from the People's Party of Canada, who himself got slandered and lambasted in 2018 during the first federal elections. He's the only one out there seemingly with any interest in civil rights and respecting those while responding to crises, and also responding to crises in a way that makes sense. So that's the update in Canada, unless anyone thinks I missed something. I did miss a super chat. Let me see what I got here. Mark Roberts says, come on, Barnes. I know you have reservations about the Arizona audit, but it's made clear. People want to know more of it from your viewpoint. Try to look into it for the next. Well, I suspect you're going to talk about this more with Richard Barris, People's Pundit.
Well,
tomorrow.
The reason why is we don't have any filings. So, there's talks on as to what's happening, but the people doing the audit are waiting to perform any report. So we get preliminary reports, but not actual formalized reports. So that's why I'm hesitant to say what's happening, because we don't have a final legal document.
All right. David Nichols says, Viva, when I started watching you, I had the opinion that you were pretty Canadian polite. As this goes on, you get angrier and sound more American. I will not hide the fact that I'm getting angrier, and it's a tough thing to deal with because I don't like feeling angry. I do believe that hatred is a consuming force, and it makes people angry. It makes them cranky. It makes them, I say, unpleasant to be around. I have my moments. You could not have told me that this is where Canada would be 2 years ago. You could not tell me that this is where the world would be 2 years ago. And I find it distressing because you have people who almost feel that they need this type of coercion, government coercion. And even more depressing than that, you've had policy now that has actually conditioned people to fear freedom. And incidentally, that's the name of the vlog I'm going to release right after we finish this stream, Robert. But people have been conditioned to actually fear freedom. They've been conditioned to jump off the sidewalk when they see someone. I saw a screenshot. I don't know if it's true, but the guidance was turn your head away from someone when you see them in public. It is inhumane, unhuman guidance that people have been conditioned over the last year to not only tolerate, but believe is necessary for their own existential physical survival. And it's absolutely distressing. And then you see what it's happening to the kids, and you see the way the kids are getting traumatized. I'm going to get angry if I say it. I'm down the street from a high school. I see the high school kids every day during lunch when I'm out there tickling my dog's piss into the sewer. And I just talked to them one day. I said, what's it like to be in high school now? I couldn't imagine being in high school now, where being a rebel is not puffing on a cigarette at break. It's pulling your mask down at break. I said, how do you guys what do you do? What do boyfriend girlfriends do? Can you hold hands? Do you pull down your face mask to kiss? And the answer they gave me, without getting into it, was just depressing, because we are robbing kids of their childhood for reasons that have no logical sense, no statistical sense, no demonstrable sense of evidence. Barring the most obvious stuff, it's just we're stealing from kids. And it started off as you're selfish because you want Granny to die, and now it's gotten into the world where the people who are allegedly protecting Granny are basically saying, I'm prepared to sacrifice our kids' futures for the odd chance of eliminating a 1 in a million risk for people who are not at risk. It is soul crushing.
The nice thing is, if I was in high school today, it'd be much like when I was in high school before. For various reasons, I'd be in the principal's office. So I did an anti-war protest, and the school's bus was in the background, and so that got me in a little bit of trouble, and other forms of trouble. Almost all legitimate political protests, at least in my view. I got the wrong person elected to student body vice president once, and so they had to fix the election. So I learned about fixing elections early. The Christian school vice president fixed the election to prevent the illegitimate winner from winning.
But Robert, appreciate that we're now in an era where, the rebellious behavior, which is now idiotic rebellious behavior is being criminalized. And you have university students being kicked off campus, being issued massive fines, and kids were being expelled. I don't know the details. I just know I saw the story on Diagonal. They posted a picture of them maskless, too close to each other, off school, and got suspended from school. If anybody knows the details, get it in there. But we're living in an era now where normal human behavior has been criminalized, and you expect people to grow up without, on the one hand, deep psychological trauma, and on the other hand, a deep resentment for the adults that did this to them. I know of cases where parents were just following the government orders, and I expect those kids to grow up to hate their parents for what they did, because it's nothing short of government-sanctioned child abuse.
Well, credit to two cases of people fighting back this week. Rand Paul fighting back against Fauci, exposing his many lies. I mean, it looked to me like he committed perjury before Congress when he claimed not to be funding gain-of-function research around the world, and they call them biosafety labs. They're more properly labeled bioweapons labs. Look up Francis Boyle and other people on this subject. Go to the hush hush from a couple of weeks ago at vivabarneslaw.locals.com, and you can find a discussion we can't quite have fully here on YouTube. But great by Rand Paul exposing Fauci for the fraud that he is, and potentially legitimating potential charges down the road, though the Biden Justice Department will never bring it. And then credit to the lawyers for the other police officers in the George Floyd murder trial that were going to be tried together with Chauvin. Their trial has now been moved to March 2021. It does appear to me that I think the judge has doubts about their guilt, but now it's more clear the judge, Peter Cahill, did not have doubts about Chauvin's guilt, based on his agreeing to almost all of the aggravating factors for increasing Chauvin's sentence in ways. It was why I told people that often you don't get a better trial by a judge than you do a jury in a case like this. It explains a little bit more his venue decisions and some other things. And it was, he wanted a trial that looked good, but it came to the same outcome that trial did, is my takeaway, because he kind of went past the pale on some of these aggravating factors that I think weren't quite justified by the facts. But he did move the other trial to March of 2021 on the guys. I mean, March 2022. Apparently, on the guys that would be enough time to remove the taint of the Chauvin verdict in Minneapolis. He plans on not. He won't set aside the verdict given what he did in the sentencing on Chauvin, and he's clearly not going to move the venue on behalf of if he's just moving it out to March 2022. So they need to document the file with good polling and survey data to show the problems with having that trial still in Hennepin County. But they're also now charged federally too. So it's a crazy environment. But the lawyers filed a motion detailing all the prosecutorial and police misconduct that had taken place in the case, or not all of it, but large portions of it, particularly the illicit attempts to influence the medical examiner's testimony. So I will see. I'm sure the judge is not going to meaningfully deal with it, but it's clear they're going to fight even broader, harder, and longer and tougher than Eric Nelson did, because they have stronger grounds. They were subordinates. One was a 4-day-year-old working rookie, who several of them had recommended moving Floyd to turn him over. So, the fact they've been charged is even more political, frankly, than to some extent than I think the Chauvin case turned out to be. But it's good to see those lawyers fighting back and showing no fear, because it'd be easy for those defense lawyers to just play along, do a nominal defense after what happened. I mean, after they saw the public reaction when the president of the United States cheered the verdict. But instead, they're doubling down and going more aggressive. So credit to criminal defense lawyers standing by their clients, even when it's going to lead to public hatred.
The other three three judges is even worse. The other three accused, the cops, are they out on? They're out on bond. They're not in.
They're all on bail. So yeah, okay. They're not in jail pending trial.
The Freudian slip about lawyers and judges being in jail. Raise that attitude bar and come to Texas. Okay, so hey, look, I think we covered everything, Robert. In
just briefly to Beavis's question, I have doubts about the hack. We don't know what the legal consequences are yet. The official narrative is that a Russian criminal organization, not the Russian government, but a Russian criminal organization, maybe based out of Ukraine, sent ransomware and pulled off the hack, and then sent back the means to undo it, and the means weren't successful. I have serious doubts about the official story. And the reason is and I'll talk about it more at vivabarneslaw.locals.com, because certain theories are not permitted on YouTube, but are allowed at Hush Hush. And so you can see them there. But I'll give the general reasons. It's highly unusual that our oil's energy security could be that easily hackable and not quickly remediable. So I find that doubtful. And if you follow the money, it might lead, or follow the power, it might lead to a different place than where they're saying right now. So that's where I have it for. But I'll do more in a future Hush Hush.
And I'm hoping that if nothing else good comes out of this, I have a theory that maybe they're going to revisit the Keystone Pipeline shutdown on the basis of necessity. Then Biden gets points on both sides. But at the very least, people might now appreciate the immense value of energy independence. And Teslas are good if you can afford them, and if you can, charge them. But there are certain essential items that are required that maybe people shouldn't poo-poo on too quickly and cheer the end of, while we're still utterly dependent on them for the most part. Robert, end it with something good, and stick around. We'll say our proper goodbyes.
Yeah. So one book behind me is about the Aleph, about Einstein's interest in numerology related to the Kabbalah tradition, which is actually fascinating. It's really the idea that you can find the divine in things like math and numbers. And I've always liked that the archives of nature and the rights of man are the two schools of learning that no state or system can ever close, that no pope or prince, no power of the church or the state can ever foreclose. And we're seeing many examples of that around the world as people push back against, whether it's Florida pushing back against the CDC, or ordinary people pushing back, like a pastor willing to take a stand in Canada, no matter the consequence. That shows the sign of the power of the conscience to push back against the corruption of the state. And as long as that's the case, there's always hope.
And everybody in the chat, thank you very much for the support. Thank you for the super chats. Thank you for share this as always. Let everyone know that we are here. vivabarneslaw.locals.com.
Yeah, we'll be in an after party right after the show. I'll be over there in a few minutes.
And I'll try to get there. And the other thing I was going to say was everything's on podcast. If you guys are interested in it, it's Viva and Barnes Law for the People. It's on iTunes, Google, whatever. And that is it. Thank you. Enjoy the rest of the week. I think we'll stream on my birthday. I think it's going to be a good birthday gift. I feel better after the streams, and I think it's God telling me to do it on my birthday so I can get boosted again. So we're going to go for next Sunday, people. Stick around for this week's Sidebar Wednesday. Maybe an extra one, we'll see. And enjoy the week. Happy Monday. Robert, stick around. We'll say goodbye.